George, are you going to be on camera?
Sure, once we get started.
Okay, great.
Great. And so I think we're going to go ahead and get started as people start joining into the meeting. I wanted to thank you everybody for joining us and thank the team at Charisma for organizing the Global Congress this year, the COVID sort of feature edition. For those of you watching on Facebook or through other streaming platforms, I would encourage you to switch over and join via Zoom if you can. We'll be taking questions at the end of the presentation through the Q&A feature in Zoom. So if you have a question, please go ahead either as it comes up throughout the talk and add the questions into Q&A, and we'll hold about 15 minutes at the end of the event to go over those questions live. So please, as you think of questions, go ahead and type them in. We won't be taking spoken questions, we'll be taking them directly through the Zoom Q&A portal. So thank you again to everyone who's joined us. We're going to be talking today about the Open COVID Pledge Project at the 6th Global Congress on Intellectual Property in the Public Interest. My name is Meredith Jacob. I'm the Project Director for Copyright and Open Licensing at American University Washington College of Law. And I am joined by my colleagues Diane Peters, the General Counsel for Creative Commons, and George Contreras, a professor at law at the University of Utah S.J. Quinney School of Law. Just to get started, as a sort of baseline notice, because this is being broadcast over the open internet, you should have a little warning, but this is not legal advice. So the information here is legal information. It is not legal advice. And so this is for general informational purposes, and you shouldn't act or not act on any specific legal matter based on what you've heard here. We hope this information will get you excited and will get you involved, but we cannot be your lawyers. And also, in the sort of general theory of openness and access to intellectual property, this slide deck is published under a Creative Commons Attribution 4.0 license and will be available after the talk. What we're going to cover today is a brief overview of what a patent pledge is and why patent pledges can be a tool for incentivizing people to innovate or to do other things in a technology space. We're going to talk briefly about why standardization, so why specifically having a standard patent pledge and a license that goes with it is important for having those benefits for public and for the innovation. And then we're going to talk a little bit more specifically how the Open COVID Pledge came into being and how it's structured. Finally, we'll talk about some examples of how the pledge can work, how it can actually reduce risk and improve the pace and spread of innovation, and talk a little bit about what's next, both specifically for the Open COVID Pledge, and then also more broadly, how tools like the Open COVID Pledge can better tailor the protections and the incentives of the intellectual property system to meet these large community challenges that we face in areas of health and education and climate change. So with that, I will pass the speaker baton on to my friend and colleague, Professor George Contreras. And George, I think you may be still muted.
Oh, great, thank you very much. No, I really appreciate being here. Global Congress is always a great event, and it's just as good to be here virtually as it is in person. Maybe not quite as good, but still good. So in terms of patent pledges, they've been around for quite a while, decades, but public attention was drawn to them in a big way back in 2014. Meredith, please advance through, why don't you just advance through all of the animations on this slide? Back, okay. So you may remember in the summer of 2014, Elon Musk, the CEO of Tesla Motors, issued a blog post titled, "All Our Patents Are Belong to You." This somewhat jokey post actually had a very serious purpose in that it was an announcement that Tesla would no longer initiate patent lawsuits against anyone who in good faith wanted to use its technology. Tesla at that time had several hundred patents relating to electric vehicle technology, energy storage, infrastructure, and so forth. It was going to make those patents available to its competitors and anyone else in the world who wanted to use them. This drew a lot of attention and actually a lot of questions about what was going on here. And so this actually kicked off some interest in the academic community, and a number of us began to take a careful look at pledges that patent holders and other IP holders were making without direct compensation. And so if we go to the next slide, we will see that you can come up with a definition for what a patent pledge is. Right? It's a voluntary commitment made by a patent holder to do what? To limit the enforcement or utilization of its patents in some way without any promise of direct compensation to do that. We go to the next slide. We can see next, just go through all 4 of these here. Okay, so you can see that these patent pledges have been made across industries in a number of different ways. They began in the 1990s with companies like Sun Microsystems, IBM, Google, pledging patents relating to the Linux operating system and open source code in general. And they said that if you implement, they wouldn't assert their patents against any implementation of the Linux operating system. These companies held many hundreds or thousands of patents that potentially would have been relevant. In the area of interoperability standards, competitors routinely get together to develop standards. And one of the conditions in doing so is that those competitors will make their patents available to anyone who wants to implement the standard, either royalty-free or for a royalty-bearing license that is fair, reasonable, and non-discriminatory, or FRAND. In the green and clean technology space, pledges were made starting in the mid-2000s. Something called the Eco-Patent Commons was created by a number of large companies led by IBM to make available for public free use patents relating to climate change, sustainability, and other green technologies. And you see these pledges even in the biotech sphere where you wouldn't necessarily expect them. Individual patents held by universities and pharmaceutical companies have been made available on a similar basis. So next slide, please. So while I was at American University with Meredith and others, we began to assemble a database of these patent pledges. It's still up, you can find it here. It probably needs to be updated a bit given some of the recent activity that we'll be talking about today. But in general, you will find hundreds of different pledges, lots of different IP, with a variety of different types of conditions associated with the pledges that are being made. Okay, so next slide. So one of the main questions that we have asked and others have asked in looking at and studying patent pledges is why? Why would a company or a university do this? Patents cost money to obtain, anywhere from $10,000 to $50,000 in pure patent prosecution cost. It's a valuable asset once you have it. So why give it away, or why lessen your ability to enforce it to its fullest? And there are a number of theories that exist around this. And many of these motivations can exist concurrently. In some cases, companies like Tesla might want to induce the market to move in a certain direction. That is, to move toward electric vehicles and an electrical vehicle infrastructure. A single company like Tesla couldn't create the national infrastructure and product pipeline that would be necessary to have electric vehicles become the norm in the United States. That requires an entire industry. But if one company is holding patents that control or block others from entering the market, they might not enter that market. So in order to compete with Detroit and the gasoline-powered vehicle industry, Tesla did something very smart, which was open its patent portfolio to encourage others to join and to make electric vehicles, to make parts of the infrastructure, and so forth. And it looks like that's actually working. Tesla continues to do very well. Interoperability standards are a similar story. I make my patents available for a standard like Wi-Fi or 5G because I may want to make some money off of my patents, but I also may want to sell equipment or services that depend on all of these products being able to interoperate with each other. There are some other types of pledges that bring up other motivations. Number 2 here, collective action relates to something that is viewed as a social good, but which requires lots of people to do in order to be effective. So for example, there are pledges that say that the pledgeors will not transfer their patents to patent assertion entities, so-called patent trolls. It's fine if one company agrees to do that, but that's not going to reduce NPE litigation. But if many companies get together to do this, it actually might have some effect on the market. Voluntary restraints are pledges that are made by individual companies, usually, in order to please or appease a governmental agency or regulator. If you're being investigated by the Federal Trade Commission for anti-competitive practices, well, then you may want to pledge some of your patents to say that you're not going to do the potentially anti-competitive thing that they were investigating. This also works with litigation. You can pledge some of your patents so that a court will look at you more kindly. And then finally, and one of the more relevant motivations in the area of COVID-19 is the mission-oriented pledge or philanthropic corporate social responsibility pledge. This is what originally led to the eco-patent commons that I mentioned before back in the mid-2000s. It also has something to do, whoops,
Sorry.
back. Yeah, it also has something to do with the pledges that we're seeing today in terms of public health. And so why don't we advance to the next one? So one thing that I'll mention, and also I'll give a plug for the book that Meredith and I compiled a few years ago with articles from around the world on the phenomenon of patent pledges, pictured here on the right. There are a number of different structures that pledges can take. They are intended to be legally enforceable obligations and commitments, and we believe they are, and there is case law, at least in the United States and many European and other countries, indicating that this is the case. A pledge can be either standalone. All that you do as a company is make a public statement promising that you won't assert your patents, that you won't transfer your patents to non-practicing entities and so forth. That commitment is generally enforceable. Some pledges are a bit more complicated, though, than simply not asserting or not transferring patents. Those types of pledges are often coupled with a more lengthy and detailed license agreement. So when I say I pledge to license my patents to you on fair, reasonable, non-discriminatory terms, well, it's not entirely clear what that means. And so the license agreement itself to grant that license is something separate, something linked to the pledge, but beyond the pledge. And so there has been a lot of legal thinking about the enforceability of these types of coupled pledge license arrangements. We do think that they work. The licenses generally are public licenses that we see along the lines of open source code licenses that simply come into effect for anybody who wants them. But there are negotiated licenses as well, particularly in this area of FRAND commitments. The licenses are complicated, they're fairly long, and even though the royalties are limited to fair and reasonable levels, they can still be quite high. And then we move to the next slide. Okay, so here I'll very quickly talk about some of the alternatives to pledges that exist in the area of opening up IP for public health purposes. On the next slide, some people ask, why isn't this just a public domain? Why don't we contribute these patents and other IP to the public domain? And there are numerous reasons why IP holders would prefer to retain ownership of their IP, including using it defensively if they are then sued. to make it appear that they still have a valuable intellectual property portfolio, to attract investment, possibly to use the same IP on a commercial basis that they're pledging in a particular area without commercial basis. So for example, in the terms of COVID-19, if you pledge your patents with respect to their use in COVID-19, you're free to charge for their use with respect to other indications. And then finally, if the license contains other conditions, like many open source licenses do, in order to enforce those, you do need some intellectual property ownership. It's harder to do that from the public domain. On the next slide. Why don't you just click through all of these. So this is compulsory licensing. This is often viewed as an alternative to pledges. It exists in many countries. As most of you probably know, this is authorized under international treaties such as TRIPS. In the past, it's been utilized primarily to compel access to medicines in developing countries, in Asia, in South America, in Africa. More recently, we've seen compulsory licensing orders and measures being taken in other countries, Israel, Germany, France, Canada. There's been strong political pressure to do this in some countries, but also strong political pressure against compulsory licensing in countries such as the United States. Next slide. And then the final thing that I'll mention as an alternative mechanism is an IP clearinghouse or pool. These do exist. The Medicines Patent Pool has been in existence for about 10 years, organized under the auspices of the World Health Organization's UNITAID arm. It originated with respect to HIV medications, has been expanded to other indications. Its traditional focus has been on the developing world. It accepts licenses from companies or institutions that have patents on drugs, and then sublicenses those patents to generic manufacturers in least developed countries or elsewhere. And a good number have been granted at this point. That being said, this is not a low-cost activity. There is overhead, and it does take some time and resources to make a program like this happen. And as Diane will mention, things like this are in the works right now with respect to COVID-19. Next.
Oh, sorry.
No, I know. And so then the last thing that I'll mention is some efforts that were taken early on in the COVID-19 area relating to pledges. Back in early 2000, when the extent of the disease was becoming apparent around the world, a number of companies and institutions did come forward and say that they would pledge both patents, copyrights, also electronic designs for equipment. Medtronic and Smiths Group, both makers of hospital ventilator equipment, made these sorts of unilateral pledges. The IGI at Berkeley, those are the CRISPR gene editing people. AbbVie, the pharmaceutical company, pledged its patents relating to its HIV drug Caletra. The Wellcome Trust pledged, collected a number of publishers together to make their literature that typically is behind a firewall freely available with respect to COVID-19. And then finally, even patent assertion entities like Fortress Group, which acquired patents from Theranos, the defunct blood testing company, had begun to assert these patents against diagnostic testing companies when COVID-19 first emerged, but due to a lot of political blowback when that happened, they also ended up pledging their patents to this effort. And so with that, if we move to the next slide, I think that's enough of the introduction. I'll turn it over back to you, Meredith.
Thank you, George. There was one question that came in during your initial sort of landscape of how pledges work and what motivates patent holders to make pledges. And I'm going to go ahead and ask it now, and you can decide if you want to jump in with a quick answer, whether you want to sort of come back around to that after we've gone over the open COVID pledge more specifically. But the question we got was, you know, we've talked about this range of motivations that motivates people to make a pledge. It could be to induce other people to act, to build up their field. It could be purely philanthropic, or it could be to get some sort of regulatory avoidance. So here I think the question is there a space in the spectrum between actually issuing a compulsory license, which is this very definite government action, and just waiting around to see what patent holders, particularly patent holders like pharma that have been traditionally a little less likely to join these patent pledges, whether there's any sort of government interventions that might foster sort of more altruistic or more sort of pro-social behavior. You can either jump in now or we can hold that for the end, whatever you prefer.
Well, I'll answer briefly because I don't want to take too much time away from what's coming up. I mean, it's really the question of the carrot versus the stick, right? I mean, the compulsory license is the stick. That's really a governmental intervention that is viewed, at least in the United States, as quite heavy-handed and something that the private sector avoids quite a bit. There is a carrot approach, and some of us have written about this elsewhere, but the carrot approach would be, well, the government has all sorts of methods of incentivizing innovation, grant funding, prizes, procurement of vaccines and therapies, by government agencies for distribution. With those, that economic leverage, the government can impose conditions. It can say, well, here's a grant, it's for however many millions of dollars. If you accept this grant and then you create something related to COVID-19, you agree that you will make it available at, who knows, you fill in the blank, fair and reasonable pricing, something like that. Same thing for prizes. Part of the condition of receiving the prize for making the COVID vaccine that's successful and approved could be that you will then share that vaccine technology with other manufacturers. So if you take the money, if you take the carrot may have some strings attached. And that's certainly something we can explore in greater detail, but it's definitely an option that, some of us have really tried to push.
Thank you, George. And I think that in some ways that sets us up for my part of this, which is really a brief transition. So you left us off one slide earlier on the initial COVID-19 pledge attempts that were coming in as sort of individual or institutional actions to respond to this crisis. And I think one of the core values of the Open COVID Pledge is it moves beyond that individual action to something that has more of a coordinated effect. And so as you talked about in the pledges earlier, there's some important things to think about in the structure of a pledge. Is it understandable to the people who might want to rely on it? Is it clear what's being pledged, what technology, for what purpose, and for how long? And then specifically, is there an opportunity for standardization? And as you mentioned, governments could choose to incentivize, saying, if we're going to fund this, we might want you to make things available to the public under some terms. And having standards can also be useful there. One of the things we've seen in the space of copyright and looking at the Creative Commons licenses is that increasingly different institutional funders or government funders are using those standard licenses as a way to make the products of those grants or contracts available to the public. And that standardization, more than just individual efforts, can form a pool of materials and innovations that allow the individual contributions to be magnified and to actually give people freedom to act and a pool of useful resources. So assuming that that standardization had value, the next step, I think, in structuring the Open COVID Pledge was to think through what the design requirements would be for a pledge like that. What are the characteristics of a standard pledge plus license that you would need to really provide the greatest benefit in terms of ability to act and predictability for the people who might rely on that pledge? And so thinking through that, I think, an obvious sort of first principles sort of design thinking thing is to go as simple as possible, to go for something that is easy to understand and that doesn't require a lot of sophisticated technological resource or legal resources on the pledgeor or the pledgee to understand. I also think it's important to talk about uniformity because it can accelerate adoption, particularly I think in the idea that if you know that other large companies have taken a pledge, you get to sort of have a follow-on benefit from the work they've done to understand it. Once you see that large adopters have adopted this uniform pledge, you don't necessarily have to go back and do a sort of first principles legal analysis to adopt it yourself. And then as a user, once you've understood the pledge once, you say, I understand what Microsoft has pledged. If they've taken the same pledge as a different company, you don't need to go through and re-understand that. The other pieces are a little bit more technical, but they are self-execution. So that this is something where if people adopt this pledge and this license, it doesn't need to be sort of arbitrated and finalized by some third party. And also here, I think one of the things we see in the Open COVID pledge that is really different than a lot of other open intellectual property instruments, so like open source software licenses or the Creative Commons licenses, is that it has a limited scope. It's limited to the pandemic. It might be limited to a period of time or a certain period of art. And I think that's important too, to get people to pledge intellectual property that they see as still having value to them in certain business areas, but contributing here to this public facing effort. And finally, that it is free, that there isn't both a cost of having to pay to use the pledge or the license, or also the cost of having a system to administer it, right? So having money change hands is both expensive for users, but it also creates this centralized structure to account for that. So with those design principles in mind, I'm going to turn this over to Diane Peters, the General Counsel from Creative Commons, to talk a little bit about the process of realizing that there was this need and thinking through, okay, what would it look like if we wanted to really fill those demands of this design process and do so in a way that could happen on a time frame that would not take longer than the course of the disease itself. So on that note, Diane, will you tell us a little bit about how you thought through this?
Certainly. So first, I just want to thank Karisma and also Meredith and George for inviting me to this great session. There is so much here that we cannot possibly get through in the time allotted. And so we're all moving very quickly through our slides, but we really welcome further discussion on these matters. Before I dive into the OCP in particular, I want to provide you with a brief overview of where it falls in the numerous other efforts underway to tackle COVID-19. This list is by no means complete. It is a snapshot of various efforts, both in the private arena and international arena of major initiatives. So the OCP, as described, is a pledge that allows companies and others to enable the public at large to use their IP without fear of lawsuits. There is also the COVID-19 Tech Access Framework, which is similar. That's a coalition of universities that agree to principles around expediting tech licensing agreements. Then George talked a little bit about the MPP, the Medicines Patent Pool, expanded in March of this year to COVID-19 medicines that facilitates access to medicines through voluntary licensing, a voluntary licensing regime. The WHO is all over the place these days, facilitating and leading or otherwise contributing to myriad efforts. They have issued a solidarity call to action, which has an operational plan that is underway. It's attempting to compile in one place pledges of commitment and sharing of IP data, mobilizing those with information to contribute, advocacy, and similar in order to increase impact and effectiveness of all of these myriad efforts to help solve COVID-19. The ACT Accelerator is a global coalition. Many of you may have heard about it. They're mobilizing funds to develop new tools around COVID-19. It's coordinating international actions and want to make sure that products are safe and available at a country level. The COVAX facility, maybe some of you have heard about this. It is essentially the vaccines pillar of the ACT Accelerator project. It's co-led by Gavi and CEPI and WHO. it's trying to accelerate the development and manufacture of COVID-19 vaccines. And then there's TAP, which is a UN technology bank, UNDP, WHO, and other organization effort to promote tech transfer and local production of PPE and similar. So you have this constellation of efforts, and where the Open COVID Pledge fits into this is, it is a very simple mechanism for a community of those who want to contribute their IP in an easy, simple, self-executing way that will be reflected in, for example, the COVID-19 tech access framework and other places. So that's where we sit in this constellation. So next slide, Meredith. As to the pledge and how it operates, the most important thing for everyone to understand is that it consists of two layers. Essentially, it's the pledge plus license model that George described previously. The first is the pledge itself, a very simple statement of principles to which the pledgor publicly agrees. You can see it here. It's 5 sentences. It states, as a matter of principle, that they undertake to make intellectual property free in order to minimize the impact of the disease. Next slide. The second layer is really important because it delineates how the pledge applies to its particular, the pledgeor's particular IP. So the underlying license must be adopted in order for it to be considered an OCP pledge. We accept 3 kinds of licenses. The first are licenses that we, the founders of OCP, which include George and myself and 8 others, wrote. They adhere to the principles that Meredith and George articulated. More on those details later, but we did stick to standard, simple, legally robust legal code. The second group of licenses are what we call compatible licenses, and those are, for all intents and purposes, the same conveyance of permissions and conditions as the OCL licenses that we wrote. This includes some public licenses and some bespoke licenses. The third category are alternative licenses, but that are sufficiently like the standard OCL licenses and compatible licenses, but they do make some import some terms and conditions on the licensee or the user that doesn't make them compatible per se. So this includes licenses like the GPL, which requires share alike. It also, anything with a copyleft requirement. Note that never permissible in any of these categories are licenses that prohibit the creation of derivatives. So we don't want these licenses to inhibit innovation in this space, or if they disallow commercial use of the works that are created. For a complete list, you can check out the link at the bottom of that slide. So Meredith, next slide. So going back to the OCL licenses, here you can see the core terms and conditions of our standard licenses. I'll highlight just a few and we can revisit at the end if anyone wants to talk about the particulars. Importantly, the licenses cover patent and/or copyright in the IPR that is licensed and nothing else. No trademarks, no trade secrets and similar. Second, the scope must be at least as broad as allowing a field of use that is for diagnosing, preventing, containing, and treating COVID-19. And this does include research. Note that any compatible or alternative license can always grant more permissions than that. This is particularly the case when someone is using a public license such as Creative Commons BY license or the Apache 2.0 license, where there are absolutely no prohibitions on field of use. Next slide. Important things to note. As with almost all pledges and public licenses, there are absolutely no warranties, no indemnification, no choice of law, etc. That's not to say that someone who wants to rely on a pledge and the underlying license can't ask for those. And it doesn't say that, and it doesn't mean that the pledgeor can't extract a fee for doing so. But the baseline is that there are absolutely no warranties or indemnification, grant backs, downstream pricing constraints, et cetera, imposed through our standard licenses. So moving on. So you can see a full list. Well, since we launched on April 7th of this year, there's been a huge uptake by all types and manner of companies that want to join the movement in support of freeing up IP rights in support of the fight. Companies include global tech giants, Microsoft, IBM, Intel, Amazon, and many others. It also includes small and medium enterprises such as the Allen Institute for Artificial Intelligence, and it also includes national laboratories such as Sandia National Labs in the United States that has pledged dozens and dozens of specific patents in support of PPE in particular. And finally, it does include very small organizations that perhaps only hold 1 or 2 patents, yet those patents are very important in the fight. If you advance slides, Meredith, you can see a full list of all patent pledges on our website together with the license that they applied to their technology. This is a really cool piece of our website. This is featured IP, where we highlight and have developed in coordination with the pledging companies snapshots of what it is that they have pledged in an effort to make them more accessible and usable by those who seek to leverage those in their communities. Look at the website is really a nice, this is a feature that George actually promoted and championed inside of the OCP work. You can check that out. Next slide. So what's next? So we had this tremendous excitement coming into the project. It was first founded by a bunch of similarly minded scientists, researchers, lawyers, and others. And we built this into a project that's attracted a lot of attention at the international level. I don't know that George and I thought when we joined this effort, there would be just the groundswell, especially of major tech companies who have joined us. But what's next? First, the project is now housed at Creative Commons. We're providing long-term stewardship and backing for it. Second, as mentioned, we're trying to build credibility with international organizations and other partners. So members of the Advisory Council are involved with both CTAP and the TAP efforts described above, and also to help ensure that the pledge is recognized as a legitimate means for contributing to the larger efforts in our work in the fight against COVID-19. Third, we're working with those efforts and also internally to find better ways to connect those that have the technology with those that don't have technology. If the pledge doesn't connect those who have with those who are seeking technology, then the pledge is merely it's unuseful. So we will be helping design the CTAP database, for example, that will be aggregating IP pledges and licenses into a simple searchable database that can be accessed by others. Additionally, CC's tech team is scoping its own database that will connect to CTAP, which will allow technology seekers to quickly find relevant pledged IP under the terms of the pledge. And fourth, we're working on internationalization efforts in terms of translations, outreach, and the development of case studies and more. Next slide, Meredith. Just to drill down a little bit on internationalization, which I hope is of interest to this global community, we're launching this week official translations of the pledge into all 6 languages of the United Nations, as well as a community-driven plan for adding many dozens of more languages to that corpus. We're going to be linking the pledge to the global community, which we believe is essential for growth and scalability. We're also working on developing educational resources that complement the pledge in particular, but also the work of these international organizations that are doing the same. We think that this will help people understand the pledge, their obligations if they are relying on the Open COVID Pledge license and similar. So as a part of all of these efforts, I have to put in a plug. We're holding our global summit toward the end of this month, and we've got a couple of sessions coming up. where we'll be explaining the Open COVID Pledge to newbies, if you will, in more depth as well, along with some early adopters of the pledge to explain the motivations that George went into earlier in this presentation and what they thought when they came on board, and then also to develop outreach plans and work for the wider community. So the Global Summit is free. Check it out at summit.creativecommons.org. And then finally, Meredith, if you want to advance. So this is what we're doing now, and we're doing it actively. We're very excited about this, as is our advisory council. In the long range, our vision is quite ambitious. As noted, our pledges and most of the licenses are time limited. We'd like to convert those who are thinking about helping only in this immediate crisis to a longer term vision for sharing IP, so that when the next crisis comes along, or if this pandemic spans longer than the ultimate cutoff date of January 1st, 2023, the pledged IPR can continue to be used. Second, we're talking and thinking with others about how this model might serve other global crises. As George mentioned, you can imagine climate change, assistance at times of natural disasters, clean and green energy solutions, and others. There must be learnings that come from this pandemic and our efforts that can be translated for use with similar efforts. Third, and tied to all of this, is of course contributing to the larger dialogue of what is the responsible use of IP in the public interest, which is the theme of this Global Congress. Where are the bottlenecks that IP laws and treaties create that might be bridged in times of crisis, most especially? How can we use this opportunity to inspire a dialogue about real change? These are some of our longer term goals. We're eager to share more information with you as we continue to roll this out. Now I'm going to turn it back, I believe, to George.
What's the next slide?
So here
Yes.
we're just talking about sort of what the broad function of these, standardized pledges can be in terms of change on the ground.
Yeah, exactly. And, we've given a lot of talks about this pledge over the last months, and occasionally a question that comes up is, well, is this pledge really worthwhile? Not every company is a part of it. In fact, many are not. So how can is there really value if you have this mechanism, but not everybody has signed up? And I think the answer is yes. These pledges are not an insurance policy against IP infringement. They're not a freedom to operate opinion that you would get from a law firm, but they do have an important function, which is take a field like information technology, where we actually have a pretty significant critical mass of IP holders. If you're an individual who has a great idea for making a contact tracing app, without this pledge, you would have to think about intellectual property pretty seriously. There are lots of companies who are in this space who might have something. But then you take a look at the Open COVID Pledge and you see, well, contact tracing. Who's made this pledge? Microsoft, Facebook, Uber, Amazon, IBM, Intel, SAP, some of the world's largest software, social media, and networking companies. And with that type of critical mass, that really does open up the field and makes it more open in generally for innovators, for small companies, new entrants. So if before you wanted to make a contact tracing app and you might have had, say, a 75% chance that you would be sued for infringement by somebody, now the risk isn't zero, but maybe it's 25%. And that kind of opening up is, we think, really helpful for innovation. And this applies in a lot of fields. The pharmaceutical industry has not come on board yet. We have some thoughts about that, but protective equipment, hospital equipment, software algorithms for, for contact tracing, emergency resources, routing, and so forth. Those are there in relatively significant ways, and we think that that is helpful.
Thank you, George. So we have about 5 minutes left in the session. We have an end time at about 50 minutes after the hour. Very briefly, I want to let people know that in this slide deck that we'll post later to the webpage and to the group, we also have some links to the contact information about the pledge news site, the CC Summit, and then our contact information, and an appendix of some other pledge-related information, including a little sort of deeper dive about the legal enforceability of the pledges, some past work at the Eco Patents Commons, and the other sort of bibliographic documents about the pledge. So, sorry, I'm gonna start that again, but right now we have some time to take questions. And our first question from the audience is from the meds field and sort of talks to what you were just closing with about there being less uptake in the pharmaceutical field for pledges and things like this. And the question there is, do these pledge efforts, even though they're directed towards the same public interest problem as compulsory licenses and other tech sharing efforts in the medicine space, how can people who are sort of advocating for pledges make sure that there is still sort of air in the room to advocate for sort of harder, more enforcement or sort of access-oriented solutions like CTAP to make sure that the pharma industry that does have this sort of misalignment is also brought into the group, like to make sure that we don't have pledges as an excuse to not have some of the pharma access initiatives. Do either of you have any thoughts about that?
Yeah, I'll take a first stab, and thank you, Peter, for that question. I mean, it's sort of a very important issue. I don't think that the Open COVID Pledge is not, I think, going to be viewed as a substitute in some of these important pharmaceutical areas. I mean, but if anything, I think it can help focus attention on IP sharing and open structures for IP, where if this is not the right one for the pharmaceutical industry, then maybe something else is. But at least attention is continually being drawn to the idea that IP need not be monetized to the max in every single situation.
Thank you, George. And so we have about 3 minutes left. And so Diane, I just wanted to turn to you and see if you had any final comments. We don't have any other open questions. Anything else that you think didn't come up that you'd like to just sort of keep people on the lookout for going forward?
Yeah, so certainly, so at present, this effort has been pretty much, for lack of a better characteristic, Northern Hemisphere effort. And I think that what we really want to do and strive for is making this truly global, including the Global South. And so something to watch for will be our internationalization efforts, which we're launching in a couple of weeks at the Global Summit. So please stay tuned for that.
Great. Well, thank you.
I'd throw in, Meredith, in the list of resources that just today, a number of us who were involved in the Open COVID Pledge have an article that's come out in Nature Biotechnology that goes through some of these issues and some of the comparisons and analysis. And I would highly recommend that to people. It's written for a lay audience. There's a link that I can give you that has a free, non-paywall link to the article. So I would encourage anyone who's interested to take a look at that.
Great. Thank you very much. So I wanted to thank everybody for joining us, for taking some time, whether it is your morning, your afternoon, or your very late night to talk about this. I want to encourage everybody to sign into as many sessions in the Global Congress as they can. It's about 30, I think 35 or 40 sessions, and it's a lot of amazing content that's not necessarily always available all over the world. So thank you for joining us, and I hope you join more sessions. And thank you to Charisma and the translating team and everybody who made this possible. Have a great day.